Forum of Commercial Courts. Welcome to those attending from across the Commonwealth. Our topic for this webinar, Working Together, Exploring the Relationships between Commercial Courts in the Commonwealth and their users. We have 1 hour together. All contributions will need to be short. The emphasis will be on conversation, question and answer. After a panel discussion, there will be an opportunity for questions from the audience. In order to contribute those questions, would you please put your question as shortly as you can in the Q&A function on your screen. Overall, we hope there will be something useful for everyone. One last point, we are recording this webinar and hope that that is acceptable to all. May I begin by inviting a contribution from Lord Justice James Dingemans, who first as a lawyer and then as a judge has a lifetime of engagement across Commonwealth jurisdictions. Lord Justice Dingemans.
Well, I'm thrilled to be able to welcome you to this collaborative event between the Commonwealth Lawyers Association and the Standing International Forum of Commercial Courts. Both the CLA and CIFOC are excellent organisations. The CLA organises, among other matters, the Commonwealth Law Conference, and the next one is scheduled to take place in Bahamas in September, where legal practitioners from around the Commonwealth can share best practice and support the rule of law. I was lucky enough to be a member of the executive committee of the CLA when I was in practice. CIFOC is a relative newcomer. It started in 2017, but in the short time of its existence, it has allowed judges of commercial courts around the world to share best practices, discuss common challenges, and thereby support the rule of law. It has just produced a very important piece of work about the enforcement of judgments around the various courts of the world. You have a very interesting hour to come with contributions varying from Kuala Lumpur, Kenya, England, Northern Ireland, and it will be a session which will allow us all to explore the challenges posed by what has gone on, but also the opportunities that has been provided to all of us. I mean, for example, the opportunity to meet today remotely and at the same time to save a great deal for the environment by not polluting the atmosphere as we traveled along. May I also, on all of our behalves, thank all those who've worked so hard to put this session together. I will now leave you in the very safe hands of our chairman, Mr. Justice Julian Knowles.
Thank you very much, James. We'll move now to a panel discussion, and we have quite a panel. We're joined and are very grateful by Chief Justice Brian Sykes, Chief Justice of Jamaica, by the Hon. Justice Nalini Pathmanathan of the Federal Court and Court of Appeal of Malaysia, by Ms. Jane Colston from the international firm Brown Rudnick, based in the UK and elsewhere, and by Ms. Maria Mbenka of Kimani Kabucho Mbenka and Co. Advocates, and also importantly, the Commercial Lawyers Association Council representative for Kenya. We're going to look as a panel at 4 particular topics, focusing very much on the question of the work that practitioners and judiciaries can do together on these topics. And as I said before, we'll do this in a conversational way as best we can. As we're doing it, please don't hesitate to raise any question using the Q&A function, and we'll turn to those questions after the panel have discussed for a while. Let me raise the first question with the panel. CIFOC published general principles on international best practice in case management. Chief Justice Sykes, for judges and lawyers alike, which point in those general principles would you highlight as deserving particular emphasis, and why? If you could switch on take yourself off mute.
Yes.
Thanks.
I will answer your question by not answering your question. I think all of the rules are designed towards efficiency and getting the best value for money out of the resources funded by the state, that is the courts and judges and so on. And so we have a particular problem here in Jamaica where we do not yet have a culture of using court resources and court time as efficiently as possible. And so one of the things that I wish to emphasize coming out of the rules generally is that we have to have a culture of efficiency, complying with the procedural steps that are necessary in order to have the case moving along, because when one person is inefficient, it imposes a significant cost on the other litigants in the process. And so I'm acutely aware of this because I got some data from our statistician last night, looking not just at the commercial court, but at the civil litigation generally. And our cases on the civil side are taking roughly 4 years to go from filing to trial. And we have had the CPR now for a decade. So it tells me that the culture is not where it needs to be in terms of emphasizing efficiency, timeliness, and utilizing all the resources appropriately.
Thank you. Thank you, Chief Justice. Jane, if I forced you to pick a particular element for emphasis, what would you as a practitioner pick?
That's really easy. Mr. Justice Knowles, as a civil litigator in England and Wales, I would highlight judicial leadership. And gosh, what leadership we have seen in the last year. If I can just give 3 or 4 quick examples, and that's not even factoring in how our civil courts responded to COVID and the virus. But just in the last year, we've seen, for example, last Tuesday, the 6th of April, huge reforms in respect to our witness statements reflecting, for example, modern academic thinking about how our memories are also vulnerable to being disrupted. In September last year, as another example, we saw the injunction toolbox being rebooted by the Court of Appeal. So the search order, which was born in 1974, the Court of Appeal said, well, in our digital age, the imaging order is probably more appropriate. And then a third example, of course, is only 4 years ago, our civil courts authorised litigants to use technology-assisted review, predicted coding for disclosure. And here we have, with the disclosure pilot scheme, which will finish at the end of this year, the court creating a presumption that litigants, litigation partners like me, we should be using this technology, this machine learning. And if we don't, we need to explain why not. And that's not even yet talking about the new vision set out by our Master of Roles at the beginning of this year, which I'm sure we'll talk about.
Well, Jane, thank you very much for that. And if I can move across to Justice Pathanathan, but back to the expressions of principle in the CIFOC document, what would you pick out as deserving particular emphasis?
I think I would pick out point 2, if anyone's read the journal properly. That basically relates to mindset and ethos of case management, that essentially it's a tool for resolution. And I think that really focuses things, because often it can be a robotic, mechanical process if not utilized with that in mind. So I would highlight that. And in view of the pandemic, I would say that the use of technology has been particularly useful as well. Here in Kuala Lumpur, we do most of our case management entirely digitally on screen. And I think our greater problem has been getting compliance and finding tools to deal with compliance. Finally, one other point is case management should not be, there should not be too many case managements. That can prove unbeneficial. It can become tiresome.
Thank you very much. Thank you very much. And if, Maria, I asked you to make your own selection as a practitioner, where would you focus? And again, I think you need to come off mute. Thanks.
Thank you, Justice Robin. I would still focus on the case management, really, that from a legal practitioner's perspective, as well as a court user. And here we have to remember that when we're talking about technology, it's not available to every litigant and perhaps not all lawyers. And access to justice being one of the pillars, certainly of our constitution, we have to have that in mind. How many of our people can actually access the court and the administrative part of the court, which is what case management really would be, and self-representing clients. So technology really has to be seen as a basic necessity when it comes to access to justice, and not just as an enabler for the lawyers when it comes to efficiency. So that we don't have litigants saying that they were not aware of a particular process within the case management process within which they had to comply with, and therefore enable them have their matters heard and access the justice that they so desire.
Thank you very much indeed, Maria. If I go back to you, Jane, you gave some particular recent examples of case management techniques being developed. Do you recognize in those the sense of ethos that Justice Pathmanathan identified?
Yes, no, I mean, absolutely. In terms of being efficient and focusing on the individual case before the judge. But I suppose I was also focusing in that document on, of course, the judge's role in not only dealing with each case individually, but also because of the advantage of day in and day out sitting in court, seeing the successes, seeing the failures, being able to see that collectively to make sure that all court users get proportionate time, how the system can be, the current system can be reformed and bettered. And of course, the initiatives that I spoke about were just a couple of examples in the last few months, particularly in when we had COVID, that our judges were leading on, which are real changes, real significant changes. Disclosure, witness statements, obviously can only be improved by the use of technology and improving in that way.
Thank you, Jane. If I may, back to you, Chief Justice, you brought out the overall importance of efficiency. To what extent is the theme within the general principles, the theme of cooperation between bench and practitioner, crucial to the delivery of the efficiency that you mentioned?
Well, I think it is absolutely central to it from this standpoint, because in a sense, courts are reactive in the sense that someone has to file the document within the court, and then thereafter the court processes now will respond to that document or whatever the application is. But unless the parties and the court understand each other, what is the expectation of each other and working together to meet those expectations. We are going to have difficulties because at the end of the day, the real critical persons in this are the litigants. So the lawyers are important in terms of providing the service. The judges are providing dispute resolution services, but it is the litigants who are at the heart and center of this. And so it is important that we always bear in mind that whether we are counsel or whether we are judges, we are actually serving live flesh and blood persons. And every case has some live flesh and blood person there who is waiting for this matter to be resolved. And as I keep saying to my judges, the long judgment sometimes that we write, the litigant rarely has any interest in that. What the litigant wants is a resolution, one way or the other, in a timely manner. The nice words, the flowing prose, and so on, now, that's for you and for me and for us as professionals. But the litigant is central, and so the cooperation is really, really critical. And that is something that I'll be emphasizing more because of the distressing statistics that I got from our statistician last evening.
Thank you, Chief Justice. Justice Pathmanathan, any reflection or observation on what the Chief Justice has just said?
I think the Chief Justice is absolutely correct. Cooperation is essential. Take a very simple example of resolving the issues to be dealt with at trial. That can take forever unless you have cooperative counsel who are willing to take into account what the judge is saying. Very often we will find that the plaintiff will have 5 issues and the defendant probably 20, which has to be condensed into 3. And that cannot be done without a firm judicial grip and a great deal of cooperation. So absolutely, and I completely agree that we often lose sight of the fact that it's the litigant that matters in the cause of dealing with our things.
Thank you. Maria, sometimes it is said that in an adversarial system that many of us across the Commonwealth would recognize, in an adversarial system, it's sometimes difficult for the lawyers to cooperate. What do you say to that, Maria?
Based on our training, especially here, as Commonwealth trained lawyers, that's the way we were trained, that you show up for the best, the best foot forward for your client. And most cases are won, based on your ability to disagree with opposing counsel, or to make sure your point is heard, as opposed to ADR, for example, which has picked up in practice more recently, perhaps in the last 5 to 7 years, certainly here. So even the adoption of the ADR by our courts has not really been well received by practitioners, because of the nature of our training and the nature of I guess getting paid by our clients, because even the clients want to see that the lawyer is really putting in the time and effort based on their displays in court, or on commentary online and things like that. So it really is an issue of changing our perspective and actually looking at the bigger picture, which is access to justice, like I said, and delivery of services.
Maria, thank you very much. A last word on this question, Chief Justice, in response to Maria's points.
The question of training, I had an occasion to speak to the graduating class of the Norman Manley Law School about 2 years ago. And one of the questions that I raised with them was, what type of lawyer are we producing for the 21st century? Are we producing problem-solving lawyers? And problem-solving might not necessarily mean, quote unquote, winning the case at the expense of the defendant. It might mean taking a broader view and asking yourself, what is the best solution in the circumstances? And I started reading a book last year called How to Get to Yes Without Giving In. It came out of the Harvard negotiation project. And I think it is a useful book for, I think, all lawyers to read. And essentially what the gentleman is arguing is that whenever you have a dispute, both sides have an interest that they want to advance. So the critical thing is recognize what that interest is. Put your interest on the table, the other person puts his or her interest on the table, and then you said, okay, how can we negotiate around this to arrive at a position that accommodates both interests? And so in that frame of mind, it's not so much winning at the expense of the other, but really trying to arrive at a solution that accommodates the interests of both parties. And so to that extent, if legal training could be adjusted to encourage counsel and of course the courts to seek to cooperate and arrive at an acceptable resolution, then it would go afar. And that is really what mediation is about. It is really trying to change that culture. But if we started a bit earlier in the legal training, then maybe in another 15 to 20 years, when those persons begin to become the senior lawyers, the judges, the law partners, will affect the culture positively in that. This is not to do away with litigation. You may still need that in some circumstances, but not in all cases.
Chief Justice and panel, thank you very much indeed. We'll move to the second of the topics for discussion. To what extent has achieving success with technology depended on the involvement of both bench and bar, and how? Justice Pathmanathan, your response to that question.
Yes, I think it's quite clear that success is almost entirely dependent on cooperation between the bench and the bar. Without cooperation from the bar, I think the bench is severely hampered. There are unnecessary delays, adjournments, access to justice is adversely affected, and ultimately the litigant suffers. With cooperation from the bar, all our new advances in technology that all courts, I think, across the Commonwealth have sought to utilize over the pandemic are able to be utilized to their fullest extent. And often we find that members of the bar can actually suggest more expeditious and sensible ways of getting around what appear to be difficult problems, particularly when it comes to courts of first instance with trials. Moving into virtual trials has not been easy. And there, the actual input from the bar has been particularly helpful. In our experience in Malaysia, the bench actually played a very strong role in initiating and insisting on the use of technology, particularly in view of the pandemic, of course. And at the outset, we didn't have our legislation in place till something like 9 months later. So we had quite an uphill task getting lawyers to actually agree to doing matters virtually, be it case management, be it interlocutory hearings. We then had to use our existing law to coerce, persuade, induce counsel to accept this. And despite the seeming anomaly of the fact that a lack of hearings leads directly to a loss of earnings, the level of distrust in terms of technology was considerable, especially with senior counsel at the appellate level. So apart from engaging the bar, we then literally took the bull by the horns and actually refused adjournments. And counsel had no option but to appear. And that seems to have broken the camel's back, so to speak, because the position has reversed almost magically, with now the most senior counsel of the bar completely converted and almost becoming techies. Because I presume it's very comfortable to sit in your office with your cup of coffee, not far away, hidden from the screen, and submit. On an appellate level, at least, it's proved really good. With the younger members of the bar, it has not been an issue. Now we're looking at virtual trials. That's coming along a little more slowly. But with cooperation from the bar, guidelines are far more easily worked out. So I would say essential.
Justice Pathmanathan, thank you very much. Maria, this plays very directly into the important point you made earlier of achieving access to justice if one's going to use technology in a way that is available to the full range of users. What would you add to the subject about achieving success with technology? How do we bring that about? Can we do it just as judges and lawyers? Or what more is needed?
Thank you, Justice Knowles. Certainly, access to the infrastructure itself was a first barrier. And for a long time, we spoke about in Kenya, certainly, about the digitization of the courts. And it was, perhaps the fashionable thing to say until COVID happened. And we were really all thrust into accepting that this is the new way of doing things. And the judiciary, thankfully, had prepared for this, and whatever was ready at the time was, they had to start. The bar was sadly a bit late to the game, I would say, because one, not a lot of lawyers have embraced or by then had embraced technology on a day-to-day, on a day-to-day basis, especially when it came to their cases and running their cases in court. And therefore, the traditional way of doing things really had to be done away with, and change in mindset and start training lawyers on this kind of thing. And this is something I really, really put an emphasis in when I was a member of the Law Society of Kenya, heading the ICT and IP committee. And we spoke a lot to this and trained a lot of lawyers, so that by the time, even with our involvement in the court management program, which is now been adopted by the judiciary, when the judges started delivering their judgments, because initially that's how it happened, that the judges here were delivering pending judgments and taking pleas in the criminal cases, and then eventually developed cause lists, online cause lists, and bar bench committees, and ensuring that the digital cause list is available, ensuring that there is internet access in a particular court, because in the beginning it was quite a mess, and using different platforms, the courts preferring to use the Microsoft Teams, or whereas the practitioners are used to either Google Meet or Zoom. So just getting all that to work required a lot of synergy between the bar and the bench, and we seem to have gotten it right now. We have courtrooms that have actually been set up as virtual courts for litigants who do not have access to the internet, where they can actually sit and listen to their matter. Obviously taking into account the COVID situation, where you want to decongest the courts as much as possible. You have also virtual courts set up in the police cells, as well as the remand prisons, so that you as a lawyer can handle the matter while seated in your office. Your client would be in the police cells or the remand, and the court then would also be on. So this has actually improved access to justice in many ways that we would not have hitherto have expected. And so it's a pleasant progression for us.
Maria, thank you very much. Jane, honing in on commercial cases, do you recognise the experience that Justice Pathmanathan identified, which was a reluctance from some of the profession, but changing over to some enthusiasm? Or what's your experience?
Mr. Justice Knowles, I wholly agree. I think in lots of my discussions, I'm incredibly interested and very techy. So since probably 2016, I've been talking about technology. I remember talking at an IBA conference in Zurich. We had a number of judges on the panel, and I'm happy and proud to say that England and Wales were one of the more techy courts. And of course, it's a partnership between the legal representatives, the bar, and the judiciary in order for us all to come up with technology which will make us more efficient in terms of what we're doing at the moment. So, for example, the lawyers recently have come up with using technology to serve the court documents, so essential, as we'll talk about later, in terms of enforcing a foreign judgment. So service by WhatsApp, service by an encrypted online data room, all of this use to make us more efficient and to stop the cutting down of all of those trees with the paper. But of course, as Maria said, and as you mentioned, of course, I do think we have a schism where we have a lot of lawyers who are clinging and hoping to go back to how we were, and a lot of lawyers who only see the way forward to increasingly use this enabling technology. And I was listening to something on Radio 4 the other day about the IBM's Project Debater, I think it's called. In essence, they've produced a computer which actually can debate at Cambridge University and can literally listen, comprehend, and rebut an argument. Now, that's extraordinary computer programming. And so I'm definitely one of the lawyers who thinks we have to increasingly embrace this capable technology.
Jane, thank you very much. Chief Justice, can I ask you this? You've recently launched in Jamaica the Commission of Senior Judges of Parish Courts. Will that include the programme of work for that commission? Will that include bench and bar looking at technology together? How will you go ahead with that? I think you may be on mute.
Yes, there's the parish courts. The parish courts are the level of courts just below our Supreme Court, and our Supreme Court is not, it's a trial court. It's the equivalent of your High Court in England and Wales. And so that is where the vast majority of our citizens come in contact with the legal system. So in order to increase efficiency, we had a commission now established to have the senior leadership of the court to meet at least once per quarter to discuss developments in their particular courts and across the system generally. And of course, the whole point of that is to increase efficiency. And that means utilizing technology in a better way. So those courts, they have some equipment installed there, but we're not utilizing them as well as we should. And part of the difficulty there is the ICT support, because for it across the island, we do not yet have enough of those persons in place. But nonetheless, we are pushing forward to utilizing the technology, and each parish court, because we have 14 parishes here in Jamaica, Kingston and St. Andrew combined, so it's really 13 parish courts, will be required to establish a stakeholder committee, which would involve the judges, members of the bar, and other persons within the particular jurisdiction of that court who interface with the court, for us to find out how are we serving them, how can we serve you better, find out what their needs are, and also advise them as to what they need to do for us to assist them better, so that we are moving towards a more cooperative model. And I recall at the recent conference in Singapore, one of the speakers from the UK, I can't remember who it was making the point that in the past, courts tended to impose their rules and everybody had to adjust to the way that the court wanted to do things. The COVID-19 pandemic has shown that perhaps there's another way, perhaps a better way, in a more cooperative model where we dialogue with each other to find out how we can meet the needs of justice. Because as I said before, at the end of the day, it's not just about the lawyers and judges, but it's about the live flesh and blood client who is there. And an unresolved case in the court system means that you have some litigant out there who is waiting for justice to be delivered. So that we are going to be emphasizing the need for the bench and the bar to cooperate. And I have to assure the judges as well that it is not about compromising the independence of the judiciary. You still be the judge, but you need to hear from those who you serve to find out, well, what is the English comedy? Are you being served?
Thank you very much, Chief Justice. I want to just briefly nudge the subject of technology to a further level and ask a couple of the panel, what aspect of technology should we prioritize for further development? So not the journey we've already been involved with. What aspect should we prioritize for further development next, and why? Maria, what would you pick as the aspect to take forward next?
I think we need, previously we had the mobile courtrooms in the far to reach areas, remembering how vast the countries are in different jurisdictions. And I think this is an opportunity to still have the mobile courts, but kitted with internet facilities, because for these people, access to justice has moved even further. Secondly, I would think that in all the courtrooms, not just the high courts or you know, what we would call the district courts previously, with established courtrooms, we need in all the courtrooms what you'd call, like, I would call it an internet room, where lawyers who don't necessarily have access to, you know, technology, because they are there, would actually be able to access the courtrooms and carry out their matters. I'm also thinking of the legal aid clinics being equipped and connected to the judiciary framework, so that we're able to reach more litigants.
Maria, thank you very much. Chief Justice, back to you. What single thing would you pick for development next in terms of technology?
Well, certainly for us here in Jamaica, it would simply be along the lines of what Maria suggested to some extent. That is to say, having kiosks or rooms or somewhere where persons who may not have the wherewithal to access the internet on their own or unaided could go to some place, whether within the court building, having regard to COVID, where they could be assisted in getting their business done in an electronic space, because there's no doubt that the world is moving in that direction. And although our populations, and some of us in developing countries, not all of our population has that kind of have that kind of access, but we still need to encourage them to come in that direction. I think one way of doing it is establishing kiosks or some booth of some kind where they can come in and be assisted even by a court staff or by someone to transact their business with the court. And this, well, you said one, but one final thing, it is really simple to use applications, intuitive applications, where persons can actually interact with the court in a simple, intuitive way with these applications. There are many of them now, many examples of them that already exist without it necessarily being unduly complicated.
Thank you, Chief Justice. Justice Pathmanathan, you kindly attended, as did the Chief Justice and others, the recent SIFOC third full meeting hosted by Singapore, and a number of references were made there to ideas from technology that are there for the future. Is there an example that you would draw from that that is about prioritizing an aspect of technology for the future, with particular reference to commercial cases?
Yes, I was just, if I can just make this comment, I agree with both Maria and the Chief Justice about what they said about access to justice. But here the focus is on commercial courts. And so I must make it clear that even in Malaysia, we do have mobile courts. We have courts at various levels, but I've been focusing on the commercial courts. Now, coming back to your question, Robin, I think I found Sir Geoffrey Voss's the Master of the Rolls' comments at CFOC extremely enlightening, because I think a lot of times we tend to focus on the need to move the adjectival or procedural aspects of technology. That seems to take precedence. In other words, we all focus on how we move from the physical courtroom into the digital world, as it were. But what is equally exciting is the substantive law aspects, crypto assets, smart contracts, those areas. The substantive law needs to be dealt with there. I don't know how much technology comes in there, but certainly, as Jane said earlier, blockchain technology appears to be a very interesting area, because apart from just verification of just judgments for reciprocity, recognition, and enforcement, there's also the possibility of introducing that sort of technology into, say, our trial process, particularly for commercial matters, which are document heavy and are increasingly becoming more international and cross-border. So witness statements, even I think I made a short presentation where I asked whether it was possible to consider doing away with some of the more established modes of trial and moving into something a little different. One judge perhaps hearing examination in chief on blockchain, it's absolutely safe, and then somebody else hearing the cross, etc. I mean, there could be a variety of this, but blockchain is certainly one of the most exciting things around, and there's the substantive law aspect. AI, I'm afraid I don't know too much about. Safe to say that in Malaysia, in East Malaysia, we are using it to assist decision makers in terms of sentencing. We've started a pilot project of that in Malaysia.
Thank you very helpful indeed. And for the audience's information, the remarks of Sir Geoffrey Boss, and indeed the totality of the recent meeting of the world's commercial courts is available publicly online now. Please go to the CIFOC website, and that can give you the YouTube links. We'll move to the fourth and final subject before taking a question, an important question that's come in from the audience. If there's any other questions from the audience, please do put them in the Q&A. We're getting to the last opportunity to do so. But the remaining question for the panel concerns the CIFOC multilateral memorandum on enforcement. Reference has been made to that already at this webinar, in which each country with a commercial jurisdiction describes how it will enforce each other's commercial judgments for money. The question is this: for business users in or from the Commonwealth, what point strikes you most about that multilateral memorandum from the member jurisdictions of CIFOC, and why? Jane, a very commercially focused question, this internationally commercially focused question. How do you answer it?
Well, as a litigator in England doing international litigation, what struck me when I read this memo on Sunday afternoon was what a go-to read it is. The rules on enforcement are so complex, even more so for us at the moment following Brexit and while we wait for the decision on the Lugano Convention. And this memorandum is an invaluable clustering together of data from the 37 jurisdictions, curating them and allowing the reader, as I said, I read it on Sunday afternoon, to analyse the many similarities and, of course, the differences. But I think it's such an important document to read at the outset when you're devising your case strategy, your sailing plan. And let me just very quickly give you 3 reasons when I read that document. Was one, in respect to when you're setting your legal budget at the start of your case, and particularly if you've got litigation funders on board. Reading this document allows you to see, for example, in some jurisdictions, you have to in order to enforce, you'll have to, or you may have to, provide security for costs, an important factor in your legal budgeting. In others, they charge a percentage of the judgment debt. Again, that could be quite a significant amount of money. The second thing I noted from reading it on Sunday was it's stressed as to how you need at the outset to get some basics right, but jurisdiction service. So if you're going to use some techie way to serve, make sure that actually it will comply at the end when you get your judgment. And then I suppose my last quick point, when I read that memo, which struck me again, was how when you get your judgment, it's not the end of the story. You may have no time to celebrate, because in some jurisdictions, you have a limited window in which to seek recognition and to enforce. So for example, in China, it's 2 years, whereas in New York, it's 20. So maybe your celebrations can go on that bit longer.
Thank you, Jane. Justice Pathmanathan, what struck you most about that memorandum and why?
Yes, I think the question was the how a business user would view it. So if I were a business user, I think I would find it extremely useful in terms of planning for investment and deciding on which particular jurisdiction I would choose, because a businessman wants to be able to know when to get out, and if something goes wrong, how he gets his money out fairly quickly. So if it was pre-investment, I would find it very useful to look in to see how quickly I could get out of a tricky situation and how much money I could potentially lose or succeed in retrieving. Post-investment, I think it's extremely useful again, because it enables counsel, the business user and his counsel, to know precisely the sort of documents that have to be placed before the court, as Jane has outlined well. And so you know exactly what you have to do before you go into court, which assists you in ensuring that you get an order that you want, and your recognition and enforcement is that much quicker. So that would be useful. What also struck me very interestingly was the remarkable consistency underlying the recognition and enforcement process in Commonwealth countries, all of whom tend to have some kind of enforcement statute, reciprocal enforcement statute, and then we share the heritage of the common law, and therefore you also find the ability to recover the debt on a common law basis by instituting a process on a debt and going for summary judgment. That seems to ring true in most of the Commonwealth countries. And I think finally, looking forward, as a business user, I would be struck by how far and how much further we need to go towards achieving reciprocity in terms of recognition. And it's wonderful that we have the Hague Convention 2019 on the table, just that it's not come into effect, but it'd be wonderful if that could be signed across the board. That would really, I mean, I don't expect that to happen very quickly, but it's a remarkable step forward and very important, I think, for the future in terms of international trade and business.
Thank you very, very much. Maria, again, with a focus on the business user, could I ask whether there was a particular point that struck you about the creation of this multilateral memorandum?
Thank you, Justice. I was quite pleased to note that in different jurisdictions within Africa have actually adopted or domesticated acts that would align with this memorandum, and I'm happy Kenya is one of them. Although I've noticed, depending on the country, like Kenya has limited to the number of countries that reciprocate. So for me, reciprocity was what jumped out at me. And taking into account that Africa has come together to sign a treaty on trade, this is really important for businesses to actually look at this and see, think about dispute resolution and see how their judgments would be or would not be enforced depending on where they were doing business. So there are certain limitations depending on where you are, whether you're in Kenya or Nigeria or the Gambia. And those lawyers have an opportunity now to look at I guess it's a new area of practice for them to look at enforceability and actually venture into settling some of these disputes across the continent.
Maria, thank you. Thank you very much indeed. Let me move, if I may, to the very valuable question that Mary Kanoge has posed from the audience. She's taken the example of Dubai, where there is both the municipal or national courts and also the creation of a international commercial jurisdiction in the DIFC. That's a model of two courts in operation that of which examples can be seen in other parts of the world. And her question is whether this is a desirable development to have a municipal court alongside a transnational court. Is that desirable? Are there pros and cons that any member of the panel would highlight? Chief Justice, a sentence or two from you.
I don't have any inherent objections to that kind of development. I do not, well, I don't know much about the Dubai court, but I can't imagine that many of the litigants in that court would necessarily be in the domestic in the domestic courts. And so from my standpoint, any forum where there is a rule of law, there is natural justice, and there are appropriate avenues for persons to advance their cases, to resolve disputes, and I would be in support of that. So there's no necessary conflict between the two. And the other side of it, which of course counsel here would be interested in, the dispute resolution is in fact a growing area of earning. And so if you can have a court that establishes itself as a fair, impartial center for dispute resolution, well, so much the better.
Thank you very much. Justice Pathmanathan, a short reflection from you.
Yes, I don't profess to know much about the international courts. The nearest example to us would be Singapore, and they're managing very successfully. But I think it is certainly to two different groups of, if I can put it that way, consumers or clients or litigants, because the commercial courts in Singapore certainly are for the international commercial corporate or sort of litigants, whereas the municipal courts will tend to do all the other sorts of things. I would second what Chief Justice Sykes says. Essentially, you know, where there's rule of law, it's fine. But I don't think you would want one in every jurisdiction. That might prove a little bit fruitless. I presume centers that consider that they are sufficiently well recognized as upholding those principles or are recognized somewhat as a center would tend to set them up. And who knows, in the future, you might have Commonwealth courts or courts in various regions. Any of these things is possible, really.
Thank you. Jane, we've got only 1 minute for your thought on this question. Just 2 sentences.
Well, I think very quickly, I refer to the Master of the Rolls' vision to transform, where he talks about using the capable technology to create a new single online funnel where all disputes of whatever nature, complex or very consumer, are put into a funnel, data captured, and the technology assists us to then resolve, as the Chief Justice said, resolve disputes, because that's after all what we're all about.
Jane, thank you for that closing thought. We're now put ourselves in the warm and welcome hands of the President of the CLA, Brian Spears, for closing remarks. Brian.
Well, I'm sorry that we have brought a fascinating discussion to such a close. Judge, it has been absolutely first rate. and a great example of the collaboration between the Commonwealth Lawyers Association and CIFOC. I found it a privilege to listen in and learn from this hugely impressive and informed panel. Going to court has changed substantially in my lifetime, and I noted one of the panelists remarking how it used to be that courts imposed rules. And now we seem to be in a much more user-friendly world of consultation between the bar and the judiciary, and of evolving court processes, stimulated by the pandemic, as we have all striven to cooperate and ensure that the system of justice continues to be done. Courts and judges, of course, perform an important public service, making decisions independently and finding the right answer based on the law and the facts. And increasingly that is done by case management, such as you have been discussing. Practitioners do not like hanging about corridors waiting for their cases to get on. They don't like unexpected adjournments and delays. They cause great upset to clients, and as the Chief Justice mentioned, they contribute to additional expense and uncertainty. There is an overriding objective, of course, for many practitioners in Commonwealth jurisdictions to avoid coming to court if resolution is possible. And I very much, as a mediator and a strong proponent of dispute resolution, enjoyed the remarks of the Chief Justice about creating a system where resolutions can occur. I also noted the adversarial training that we still persist in throughout our Commonwealth, and I'm sure that there are lessons to be learned for creating the climate of resolving differences and having adjudications where only absolutely necessary, and where adjudications by a court or tribunal is necessary, that is done proportionately, fairly, and independently. The CLA is an organization of practitioners from across the 54 jurisdictions of the Commonwealth. Inevitably, we learn from each other, and today has been one of those examples. Today has also been an example of the first collaboration between the CLA and CIFOC. And can I pay tribute, Justice Knowles, to your magnificent chairing and drawing out of the opinions from our panel throughout the webinar today. This will not be the last collaboration between the CLA and CIFOC. We look forward, travel, pandemic, and God willing, to meeting in person in Nassau, the Bahamas, where there will be another opportunity to explore some of the themes that have emerged from this interesting discussion. Collaboration between the bar and the bench, the creation of a judicial system of efficiency and best value, the use of technology which is accessible and secure and does justice, even though people might be sitting, as we are sitting, remote from each other. I loved the beginnings of a discussion about the substantive law issues arising from technology as it plays an increasing part in our society. And I absolutely pay tribute to the invaluable resource of enforcement of judgments contained in the CIFOC document. With all of that, the CLA is an organization that upholds and really respects and calls out breaches of the rule of law. And we must all go about our commercial business, espousing the values of independent courts, a fair system of hearing, proper and accountable disclosure of evidence, and enough time to consider and to present arguments. And I look forward to evolving those themes in collaboration with CIFOC in the coming days and months leading up to our conference in Nassau. Thank you for this opportunity to say thanks, and well done, panel, and lovely to see you all. Back to you, Justice Knowles.
Well, thank you, Brian. And as you say, thank you to all who have spoken and to all who have attended. Bridget Watson and Claire Rowe from CLA deserve our thanks for their work on the organising, as do Grace Karras and Nikki Adewale from SIFOC. A particular thank you, if I may, from SIFOC to CLA for the great pleasure of working in partnership with you. Very best to everybody. And that concludes the webinar.